I want to do a little introduction of the ARC, and then I'll kind of go into the details. As Terry said, my name is Haley Greer. I am the director of the Master Pooled Trust, and I've been at this, as Terry said, for a little over 10 years, and I've been with the ARC my entire life, pretty much. I grew up in a family of advocates for people with disabilities, and so I was around people with disabilities my entire life. And then I ended up here probably for lots of reasons, but the ARC is an organization that advocates for people with intellectual and developmental disabilities. So that's what the ARC of Texas focuses on. However, the Master Pooled Trust serves people with all disabilities, and we'll get into some more details about how that works here in a little while, but I just wanted to let you all know that as an advocacy organization, you know, our focus is around intellectual and developmental disabilities, but we serve people with all disabilities. So while maybe some of your clients wouldn't benefit from this, others would. And so it expands the scope of maybe everybody that you know, the people that you work with currently, or even people who are in need of a guardianship. It works for a lot of folks. So I like to start the presentation off talking about what a trust is. I think that that's something that a lot of times families don't fully understand. I know when I was in law school, I took a trust and estates class. I had zero clue what a trust was when I went in, and I'm pretty sure I had half a clue what it was when I came out. But obviously I've learned a whole lot since then. And I always like to start off really explaining what that is, because I think it helps us to get a good foundation to then go to the Master Pooled Trust. One of the things that I do like to tell folks is that the Master Pooled Trust isn't going to be the right fit for everybody. So don't try to fit a square peg in a round hole. But I do this as an educational opportunity to know what a supplemental needs trust is and how that can be utilized for individuals with disabilities in a number of ways. The Master Pooled Trust, as we'll get into in a little while, is works for you know, a lot of people in a lot of ways, but it's not going to work for everybody. And so I just like to put that out there in the beginning. So what a trust is a relationship between two parties where property is held by one party, a person, an organization, a bank, a group of people, for the benefit of someone else. Every trust is going to have a beneficiary and a trustee. And so the beneficiary is the person that the trust is set up to support. And the trustee is the person that is the group of people that is going to make the decisions about how that money, that property, anything that's held in trust, what happens to that, how it's spent, that sort of thing. One of the things that I think is important for people to recognize, because I hear this a lot from folks, is, oh yeah, we have a trust. And I ask about the trust and they say, oh yeah, we have a bank account and it's got trust in the name. I said, well, where, you know, can I see the trust document? And they have no clue where the trust document is. I talk to a lot of folks who say, oh yeah, my loved one has a trust at the provider that is serving them. And that's not the same as this type of trust. And so it's important to recognize that a trust is going to be something that actually has a document associated with it. So a trust is a document that gives the rules about what happens to the money, to the property, whatever it is. So it answers questions like, is it spent? Is it saved? How much can be spent? What can the money be used for? Who can use the money? Who is this going to benefit? And what happens to the property? If there is any sort of real property involved, is it held on to? Is it sold? Does the individual live there? Are they going to come back? all kinds of things like that can be included in a trust. So it's going to give rules. Some trusts are very, very specific and some are rather broad. And so there's different ways to use a trust, but you've got to make sure you have that document. You've got to have that piece of paper. And one of the things that, so what we're going to talk about today when we talk about a trust, I think about trust fund babies. You hear on TV or in movies, and they're like, oh, they have a trust, and so and so's in charge of that trust, and you hear all the like uncle who doesn't want to let anybody have anything or whatever, some drama that's going on TV. So most people think that trusts are only for rich people. And the reality is that yes, trusts are for rich people, but they also can be used for a lot of other people in a lot of different ways. And so when we're thinking about trust in terms of guardianship and people with disabilities, we're talking about supplemental needs trust. And a supplemental needs trust, and other times known as a special needs trust, it's a specially drafted trust that allows an individual with a disability to retain assets while keeping their benefits. Okay, so here is just a few of the benefits that are what are considered means tested, which is talking about whether or not you have the means, hence means tested, to be able to pay for these things, or if these are all Medicaid services and Social Security. So these are just a number of the services that are available to people that are means tested. And so the idea of an S&T is it's going to allow somebody to have additional assets while still keeping those means tested benefits. And when we talk about this, the reason that we're talking about this, and some of you may say, yeah, I know this, I've known this forever. Not everybody does. So generally, you cannot have more than $2,000 in countable assets, countable being the important word, but also assets, countable assets, and remain eligible for a lot of means tested benefits. It's not going to be all of them, but $2,000 is kind of the general rule. And $2,000 is very specific to SSI. The ARC at a national level is working to try to get that number up, but know that you can't have more than $2,000 and remain eligible for SSI benefits. And $1 of SSI benefits gives you Medicaid. And that's an important thing for a lot of people with disabilities. And so it's important to recognize that that is the purpose behind these S&Ts, is allowing somebody to still keep those benefits and still have more than $2,000 in countable in assets. And so when we talk about an S&T, I like to talk about trusts having superpowers. And some trusts, it's, their superpower has to do with taxes. Well, an S&T superpower is invisibility. So what happens is that an S&T actually makes the assets that are held in trust, quote unquote, invisible for Medicaid or SSI purposes. And really what it means is that it's not a countable asset. It's there, they know it exists, they just don't count it. And there's a lot of reasons behind that, but I just like to think of it as funds in an S&T are invisible for those purposes. And it's important to recognize that, sorry, I thought I was going through my slides and I wasn't. It's important to think about how you can use a special needs trust. So there's lots of different ways. And depending on where you're at in a situation, what's going on with an individual, what resources, supports and services that they might have, I like to think about a trust or a pooled trust as another part of that toolbox when you're looking at supports and services. And so some of the things that we that S&Ts can be used for is, number one, to manage money. It's, there's a lot of people who don't necessarily need to have access to $100,000, $50,000, $20,000, because they're going to go and blow it. And so there you can use an S&T in a way to manage those funds. You can also use it to avoid a guardianship of the estate. For any of you practitioners here who have guardians of the estate, they can be very cumbersome, they can be very expensive, and oftentimes individuals with disabilities don't necessarily have enough to really justify the cost of a guardianship of the estate. So you'll see later why an S&T actually might be useful. It's also useful to think about individuals who are parents who are leaving money to their loved ones, and maybe there's a guardian of the person that's already involved, and they could actually establish an S&T instead of it going directly to the individual and then having to go through the whole process of establishing a trust or establishing a guardianship of the estate. It's used to protect public benefits. We talked about that. That's one of the biggest reasons that they're used, but it's not the only reason. But it is what they do, if you will. And so we like to think about it from the perspective of improving quality of life. Individuals with disabilities, especially individuals who live off of SSI, they are geniuses, in my opinion, because if you can live off of SSI, you can do anything. SSI right now is $841 a month. I don't know anywhere that you can live off of $841 a month. I just don't. And but I know a lot of people do it. And so I think that it's important to recognize that having additional funds available to you can really improve that quality of life in a lot of different ways. So that's really where we where we focus on, is that quality of life piece. It can safeguard the funds against predators and creditors. I will tell you, we have had a lot of individuals who use our trust who are being targeted in some form or fashion by some predator to use their funds. We had a beneficiary who was convinced she had met the love of her life online. She was in her 70s, he was in his 50s, and she just knew it was everything that was meant to be. And she came to us because she wanted a good chunk of her money, $30,000, to go to purchase for the down payment on a home in Atlanta. She lived in Dallas. She wanted a home in Atlanta with this new fiance of hers. So of course we entertained the question. We said, okay, well, what, give us all the details, give us all the information. We want to see all the different things. We got copies of everything. We were provided a lot of documentation from a lot of people. It took us very, very little time to recognize that all of it was a scam. And that the home was not owned by the person that was supposedly selling it. The lawyer's office was in the Braves stadium. The lawyer's bar number didn't exist. I mean, there was just so many things. It was just actually absolutely blatant. But we were able to safeguard her from using those, because had she had access to the funds directly, she would have given them to him. We got a phone call about 6 months later, and he was supposedly in Europe and needed a kidney transplant and needed $10,000. We obviously said no to that as well. But those are ways that that trusts can really use to safeguard against those predators. Another situation that we are actually, I was just talking with a family yesterday. Their loved one has a disability and has racked up credit card debts like nobody's business. They've managed to get it all sorted out, but they have set up a trust now where any additional funds that the individual has goes into the trust instead of somewhere where a creditor might be able to have access to it. And so that's something to think about as well. So if you have clients or you're talking to folks who maybe their loved one has a diagnosis that might lend to them just spending out of control, safeguarding those funds in an S&T is really, really useful. The last thing that I like to mention, and this is going to be for a lot of folks who, if you're looking at guardianship, especially for an individual who's about to turn 18, child support. Once an individual turns 18, child support becomes income to them for Social Security and Medicaid purposes. And you can actually establish a S&T to be able to have the funds go directly from the supporting parent to the trust. It has to be court ordered, but then it can actually protect those benefits. So that's something that I actually like to talk about as well. Trust can help to do that too. When we look at different trusts as an alternative to a guardianship, we know that there's a lot of alternatives to guardianship, but we also know that there are reasons that guardianships are going to exist regardless. And so one of the ways that we see this as an alternative to a guardianship, if an individual needs support with money, they might have capacity, but they just don't really do well with money, and they need some support with that. That's something that trust can be used as an alternative with. You can protect benefits for those who are over the asset limit monthly. And I say this as thinking of individuals who maybe are living in a group home or having some sort of waiver services, and their asset limit has to remain under that $2,000, but they've spent money on everything it is that they need to spend money on. They've gotten their nice TVs, they've gotten their recliner, they've gotten their clothes, they have so many clothes, and they're just constantly over that asset limit every month. Trust can be used to assist in that. We also have management trusts. So in lieu of a guardian of the estate, you can create a management trust that allows the funds to be sent to a trust rather than being held in the guardian of the estate. And it also can be used for future planning and third-party trusts that are properly planned for, so that you can eliminate the need for a potential guardian of the estate in the future, because no estate would exist. And this is when we're talking about third-party trusts. Parents set it up with their will, their life insurance policies, things like that. And then the trust is established without the need for a guardian of the estate, because the trustee can serve in capacity over those funds. There are different types of trusts, and I know many of you are very familiar with this, but I still like to go into the details of this. So there's self-settled trusts that are established with a beneficiary's own money. So this is their money that was left to them and directly to the individual in an inheritance. Lawsuit settlements, we see a ton of lawsuit settlements. Individuals who had a 401k but who are now disabled, and that's being taken into consideration for their benefits. If they even have additional savings, we also see them with SSI or SSDI back payments, where an individual should have been receiving a different amount of money or should have been receiving money, period. So they end up getting a big check and they need something to do with it. Self-settled or first-party trusts are going to require a Medicaid payback provision, as we call it. So what that means is when the beneficiary passes away, any money left in the trust has to be used to pay back the state for any Medicaid dollars spent on their behalf over their lifetime. All S&Ts established with the beneficiary's own money have to have this provision, or it will not be approved by Social Security or Medicaid. So it's very important if you're a practitioner and you are considering drafting a trust yourself, make sure that this Medicaid payback provision is in a self-settled or first-party trust. Here's some statutes that go along with these. You often hear self-settled trust referred to as D4A trusts. That's the way that they're referenced, and it has to do with the statute here. Pooled trusts are D4C trusts. And so we are we also do have a self-settled component. There's the POMS, which is the Program Operation Manual Systems, I think is what POM stands for. That is the Social Security's rule book, if you will. And then the Texas Estates Code, Chapter 1301, which is your individual self-settled trust, and 1302, which is your pooled trust, which those are both management trusts. And then Property Code, Section 142, which is going to be things like lawsuit settlements or things from minors that are outside of the guardianship realm, so or probate realm. So that is the statutes and rules and regulations that come along with it. There's also references in the Medicaid for elderly and people with disabilities handbook as well. So that's another place that you can reference. And then we have third-party trusts. So third-party trusts are going to be funded with a third party's money. Oh my gosh, I realized that I did not go through this again. I apologize. So we're going to talk about third-party trusts now. So these third-party trusts are the ones that you're going to use in your future planning. This is what you're going to be using with your clients or your families to talk to them about their actual future planning. So it's important to recognize that proper future planning will actually benefit the beneficiary in a much better way than not planning for the future at all. We talk a lot about future planning here at the ARC because we want to make sure that families understand the importance of that. When I talked about those self-settled trusts, you'll notice that they do have that Medicaid payback provision. Third-party trusts don't. And so you can use a third-party trust in a different way than you would a first-party trust. And so you're able to plan before there's a need to go through the guardianship process as far as a guardian of the estate would be concerned, because you've got that planned appropriately. And so we've got first-party trusts, we've got third-party trusts. Then we have a traditional S&T versus a pooled S&T. So a traditional S&T is going to be established by an attorney, and an attorney is going to draft that trust. An individual, a bank, or a trust company will serve as the trustee. The individual trust document is going to be created for the family's specific needs. So it may address very specific things for the individual or for the group of people who the traditional S&T is being drafted for. And then you have a pooled S&T. It's established with a nonprofit organization who serves as the manager alongside a trustee. And there are master trust documents that are already drafted. And then the assets are pooled together for investment purposes. And we'll get into some more details about that here in just a minute. One of the things that I do like to point out, in the guardianship realm, there's a lot of discussion around individuals who are over the age of 65. Individuals who are over the age of 65 who need to set up a self-settled trust may only use a pooled S&T. That's an important thing to recognize, that you cannot have a self-settled individual trust for a person who is over the age of 65. The other thing to recognize is that there still could be a transfer of assets penalty if a person needs long-term services and supports within the following 5 years. So we're talking nursing home services, ICF, IDD, or Medicaid waiver programs. And so individuals over 65 can use a pooled S&T, but you have to recognize what the trade-offs for that would be. I don't see any questions so far, so I'm going to continue on. We're talking here now about the master pool trust, what you came for to talk about today. I am going to go into details about how our trust works. One thing I will say is we are not the only pooled trust out there. If you have individuals who may be leaving the state of Texas or have potential to be leaving in the future, there are national pooled trusts as well. So I do like to let folks know that pooled trusts are, we all do the exact same thing a little bit differently. So I'm going to talk about how our trust works and the process for that. One of the things that I like to really start with is, does the master pool trust work for your situation? So there's 3 very specific things that are important to recognize, just first and foremost about the MPT. The individual has to meet Social Security's definition of a person with a disability. That's an important thing to recognize because if they don't meet Social Security's definition of a person with a disability, they cannot use the master pool trust. They do have to be a Texas resident at the time the trust is established. I put Texan here, and then I thought, well, there's plenty of Texans that have moved outside of the state of Texas, but you do have to be a Texas resident to use the master pool trust at the time that the trust is established. We do have beneficiaries who've moved to other states, and we continue to manage their trust. We also have other people who've moved and we've transferred their trust to other pooled trusts in the state that they moved to. But at the time that the trust is established, the individual does have to be a Texas resident. And then the other piece is that the master pool trust can only accept cash assets or items that can be, or things that can be changed into cash assets before they are transferred to the master pool trust. And that has to do with our pooled investment situation. The ARC of Texas serves as the manager. So as the manager, we are going to handle all the day-to-day operations of the master pool trust. That means we're talking to your clients, we're talking to their families, we're talking to the providers. We are the front line of communication. We handle all of the stuff. We approve disbursements. We do it all on the front facing side of things. We have a trustee, Providence First Trust Company. They have oversight over the entire trust, but they also prepare and file the taxes for the trust. And so that's what their role as trustee is. And then JP Morgan is our financial administrator and our investment advisor. So we work with JP Morgan and have been for the last 22 years as our financial administrator and investment advisor. And what that means is they handle the investments, but they also are the ones who send the money out. So we give direction to JP Morgan, and then they're the ones who send the checks and make the deposits to our beneficiaries and their families. Well, not to our beneficiaries, because we don't give them money directly, and we'll talk about that here in a minute. The master pool trust has 4 master trust agreements. They're already drafted. They meet Social Security and Medicaid's requirements for an S&T. Individuals join using our joinder agreement. We currently have over 2,000 active sub-accounts. And one thing that I do like to tell folks is that all 4 of our trusts help protect benefits. I'll talk about what those 4 trusts are here in just a little bit, but know that all 4 of them can protect those benefits. So the good thing with the master pool trust agreement with this master document is that nothing else has to be drafted. you use, excuse me, our master trust and our joinder agreement, which cannot be altered or changed in any way, to be able to establish a pooled trust subaccount here with the ARC of Texas. It's pooled because our subaccounts are pooled together for investment purposes. We have around $120 million right now over those 2,000 subaccounts. And that allows us to keep the fees relatively low by pooling all of those assets together, because we don't have fees that are associated with every single account. And so it allows us to keep our fees, our minimum fees, especially much lower than other trustees or trust companies. One thing to recognize is that there is no minimum and no maximum that can go into the master pool trust. So we have accounts ranging anywhere from a few $1,000s to a few $1 million. And so know that we serve everyone and we can serve anyone. So that means we do not have a minimum, whereas a lot of trustees and a lot of trust companies are going to have a minimum. And we are able to accept trusts because we run the gamut of those. We're able to accept those trusts for a much lower fee than you would have at a corporate trustee. As I mentioned before, the MPT can only accept cash assets, so just be aware of that. When we look at our pool, we have those sub accounts. So everybody does not have access to the $120 million that we have. They have access to what's in their own sub account. So that means they have access to the money that is put in, and whatever earnings or losses. Right now, you all know how the market is going, but they actually are going to share in their percentage of the whole. And so it goes right back into their accounts. We do not keep that money. It is put right back into the individual sub account. The fees, so you'll look at our fee schedule. The enrollment fee is $600. The enrollment fee gets you enrolled in the trust. It gets you the trust document, the joinder agreement, and all of our work to get that trust established. That is a non-refundable fee, and we then have our annual fees, and these are our minimum fee is $300. So we've got a lot of folks who are on that $300 minimum fee. The first 50,000 is 1.75%. The next 50,000 is 1.25%, and then anything over 100,000 is 1%. We don't have any annual fees for unfunded accounts, and that's because we do have a lot of families who have these included in their will or in their life insurance policies, and so they're able to keep the trust here, keep it open, and it's ready to go. But there's not any sort of annual fee that's associated with it. Our fees are generally comparable to a corporate trustee. However, our minimum fees are going to be much, much lower. We do have a tax preparation fee, which currently is $90. That's negotiated on an annual basis. And then we also have annual accounting fees. So if an annual accounting does need to be filed with the courts, we are happy to do that, but there is a cost of $150 to do that, which compared to a corporate trustee is again going to be significantly less, because a lot of those you're looking at $1,000 to $1,200 to file an annual accounting. So I think our fees are reasonable, and I do believe that we are able to serve a lot of people, even though we have this lower fee, and of course that's because our goal is to help as many people as we possibly can, and so we hope that our fees are reasonable comparatively. one of the things, oh, it looks like we have a question. Okay, there is a question that came up. It says, what percentage of assets are typically retained by the ARC pooled trust upon the demise of the beneficiary? So one of the things, and I'm trying to remember if I talk about this, I don't think I do. I usually include that in here. One of the things that is unique about a pooled trust that is not going to be the same as a traditional trust is that a pooled trust can actually retain funds remaining in the account when the beneficiary passes away. Currently, our joinder agreement does not require us to retain any funds. The individual or the grantor of the trust can determine how much is retained by the trust, so they're able to choose a percentage. However, there is nothing that is required to be retained by us at this time. So we would retain whatever is directed to us in the joinder agreement, and then we pay back Medicaid. If Medicaid is paid back and there are final remainder beneficiaries, those are also included in the joinder agreement. So all of this is actually outlined in this joinder agreement. So the final remainder beneficiaries are going to be the people who would be able to receive funds after Medicaid has been paid back. One thing that we find with a lot of our beneficiaries is that they have Medicaid reimbursements in the millions. And so a lot of times there are not going to be funds that are available to pay the final remainder beneficiaries. However, they're still included in the joinder agreement. For court-ordered trusts, the estate is the final remainder beneficiary, and we don't retain anything in those situations. Our joinder agreement can be found at thearcoftexas.org/trust. It's on our website. Here's some basic information that we like to make sure. The grantor is going to be typically going to be the individual, their guardian, or a power of attorney. The people who can establish a self-settled special needs trust here, so we're talking about an individual's own money, is going to be the individual, the parent, grandparent, guardian, or court. That is who the federal law allows to establish a self-settled special needs trust. But typically we see it as the individual, the guardian, if the guardian has one, or the power of attorney. Sometimes it depends on how the court order is written. The court is sometimes listed as the grantor, and the guardian signs it on behalf of the court. Other times the court directs the guardian to establish it as guardian. And so depending on what your court order looks like, that would be what would happen there. If you do want to establish, pooled trusts are established under section 1302 of the Estates Code, which is separate from 1301. 1302 specifically governs the establishment of a subaccount. And so be sure to reference 1302 in your court order if that is what you're looking at. If you need a sample court order, we have them. Please reach out, let us know. We're happy to work with you. I do recommend that you share your court order with us before you file it with the court, because oftentimes they don't include the proper documentation that Social Security is going to need, the proper wording that Social Security is going to need in order to accept it as a court-ordered trust. So it's really important that we have the proper language in there for Social Security to be able to accept that. If there's a guardianship, please include letters of guardianship or powers of attorney. The beneficiary is going to be the individual with a disability. We get a lot of questions about that. So the grantor is the person establishing the trust. The beneficiary is going to be the individual with a disability. The grantor and the beneficiary can be the same person. The primary representative is the person that the ARC actually works with. And it can be the individual with a disability. It can be someone else on their behalf. And so that's the person who actually communicates with the Ark of Texas and requests funds. So the primary representative is listed in there. Be sure that you get the joinder agreement notarized in the section acknowledging the grantor's signature. That's an important thing to recognize. We often get a lot of them that are not notarized. So please make sure that you do that. Send the enrollment check for $600 made payable to the Ark of Texas, and the funding checks made payable to the Ark of Texas. Honestly, it's usually the Ark of Texas MPT FBO, which is the Master Pooled Trust for the benefit of, and then the beneficiary's name. You'll send the original to us here at the Ark of Texas, and be sure to send a copy of that court order with the joinder agreement if you've got a court order. And the piece that we really talk about is make sure that that court order directs the appropriate person to establish the account or directly orders that the account be established. That is very important to make sure. Again, that's a Social Security thing, not an us thing. That establishes getting it set up. The next thing that I want to talk about is disbursements. One of the things that I think is very important as practitioners, as family members, as people in the court, is making sure that individuals with disabilities and their loved ones understand how distributions from an S&T work. And I think it's important to recognize that a lot of the rules that I have to follow have zero to do with what I think is right or what is logical. And that's an important thing to recognize, is that there's not always logic in Social Security and Medicaid rules. So the number one thing is that it has to be for the sole benefit of the beneficiary. I understand that they live with somebody and they need something. I understand that giving somebody else access to something would benefit that person. There are lots and lots of things that people ask me about that are not considered sole benefit. So it's important to recognize that just because the beneficiary may benefit from it, if a lot of other people do as well, then it's not going to be considered sole benefit. We cannot pay for food or shelter generally. There are lots and lots of ways to pay for food or shelter now, even from a special needs trust, but we don't pay for them directly usually. It all has to do with how what benefits the individual is receiving, and exactly how it is that we can pay for, as well as when their disability started. So we've got ways to do that, but generally we're not going to pay for food, and we're not going to pay for shelter. We cannot give cash, period. No cash, can't get cash at all. Cash is considered income, and nothing that would be considered a non-exempt asset. So for example, if you already have a car and you need to buy another car, you have to get rid of the first car in order for us to purchase the second car. So you've got to trade that car in, even if it's old, even if it's worth nothing according to you. Social Security sees it as an asset if we were to purchase the second vehicle. So things like that are really, really important to recognize, and recognize that there are a lot of rules that I don't like, but I still have to follow. And so it's important to set expectations for your clients when it comes to getting distributions from the MPT or really any S&T. I think it's important to recognize that there are a lot of rules that are really annoying. I can't pay your child support. I can't pay for your children to get something. All of those things are very important to recognize. And these may not be situations that you're looking at in guardianship, but it might be in something else that you might be looking at. We have a toolkit. We have a toolkit that is very long. We're actually in the process, and we'll have an updated one in the next month or so. It's not significantly changed, but it does have some updated information. And we send that toolkit out to everybody who enrolls in the trust. You get a hard copy, but it's also available online. Anybody is welcome to go check it out. You can find it at thearkoftexas.org/trust-toolkit. Everything that you need to know is pretty much in there. One of the things that we like to point out is that is how to request from the master pool trust. So we have to have everything in writing. We have too many beneficiaries. We have too many people that we serve to not get these things in writing. As much as we appreciate that there are situations where it's hard to get something in writing, we really need something in writing. We do have an acknowledgement of policies form that's a part of that toolkit. So if you are setting up a trust, make sure that you read the policies and acknowledge them for us. One of the things that we talk about significantly in that, significantly is probably the wrong word there, we do address in that acknowledgement of policies form is the need to prepay for funeral services. So be sure to check out that section if that's something that your loved one, your client, the individual with a disability may need. We have a disbursement request form that can be faxed, emailed, or mailed, and we will have an online component to fill out that form in the next month or so as well. So we will be having some updates to our website that include those things. And hopefully that will allow for individuals who might have issues with printing something out or being able to send it in that way. One of the things that we do require is that you provide receipts. So if you want to be reimbursed, receipts have to be provided up front. If we're going to make a direct payment somewhere, we need to see an invoice. And if funds are going to be advanced, which we do in a number of ways, we will have to have receipts on the back end in order to document that request. So it's important, especially if you're involved with the court. I need to have every single thing documented appropriately. Same thing for Social Security. So it's really important that we get that in. The online component will hopefully allow us to accept those copies of that or pictures of that a little bit easier for folks as well. We have a general guideline for disbursement requests. This is going to be available in the toolkit. It's also available on our website. Some of the things that we do pay for, I mean, you can see that the list of generally allowed is very long. Generally not allowed are really the things that Social Security and Medicaid or SSI and Medicaid don't allow us to pay for, or don't allow us to pay for without there being potential implications to the amount of money or the services that are provided. We are well-versed, in my opinion, in benefits. Benefits can be very difficult. Understanding both the asset limits and understanding the income limits and how you can qualify for benefits is very important, but also understanding how different distributions are going to impact those benefits. And so it's important that no matter who you go with, again, we might be the right fit, we might not, but as an alternative, I think we're pretty good. But make sure that whoever you do go with does understand those benefits and understands those programs. Every single program has different income and asset limits within the Medicaid system, and Texas has about 120 different Medicaid programs. So it's important that I do not know every Medicaid program, but we do know a lot of them that individuals are receiving. And so it's important for us, and as a practitioner in this part of the law, recognize that it's not easy to always make distribution decisions. We're actually currently having a discussion right now around a generator for an individual with a disability who doesn't own their home. And so there's a lot of things that you really do have to take into consideration when you're making distributions and whether or not they will meet Social Security or Medicaid's rules. And so it's important that you know somebody who can understand, or that you have somebody who can understand those rules. And then the last piece that I wanted to talk about is taxes. So self-funded subaccounts, so my own money that I set aside for myself, receives what's called a grantor letter in the mail. And that's going to be sent from us to the primary representative. We do not know the individual's tax situation. We cannot file a beneficiary's tax return because we do not have that information. However, we do file the taxes that are associated with the trust. So that will come. We try to get it out as quickly as possible, but it will be to folks at the end of March of every year is really when they go out. And that we recommend taking to a tax professional and filed with the beneficiary's tax returns. We don't have all of the information about a beneficiary's tax situation. We don't know what their income is. We don't know any of those things. So we're not able to provide any sort of tax advice. I am not a tax attorney. No one here on staff does taxes. Our trustee can help answer questions around them, but you will need to find your own tax professional to file the beneficiary's tax return. A lot of our beneficiaries don't have taxes filed, but it is something that we do like to let folks know. And with that, I have finished my very fast and long presentation. We have one more
Haley,
question.
yeah, there's one more question, please.
Yeah. If an individual is not disabled, are there alternatives to an MPT that has much of the same benefits? It depends on age. There are some national trusts that do have trusts that are not based in the D4C range. There are some ones for minors, as well as I believe some others, but they're going to be at the National Pooled Trust. I can give you some recommendations that may be able to help you, because there's lots of pooled trusts out there. So again, I think we're pretty fantastic, but I also know that we're not always going to be the right fit for everybody. There are some pooled trusts out there that do take property. So if you are talking, if you've got a house or if you've got property or mineral rights, things like that, there are some trusts that will accept those that are national trusts. So you can take a look at that as well. Happy to give anybody information on that. And then here's our contact information. Please feel free to reach out if you have any questions or you need anything from us.